How you all doing? Yesterday was April 2nd, 2010. There was a hearing in regards to the evaluation proceeding that was involuntarily imposed on April when she was sent out to the Winnebago Mental Health Institution for observation based on the fact Article 1 Judge Thomas Donegan was upset that April did not agree with the fraudulent sham pleadings to plead guilty to a so-called criminal offense that has no elements of an offense being a crime. And so one of the things that I wanted to tell you all was that the report came back and April was found to be competent again, again, again. Of course, the parties in the proceedings that are trying to violate and are violating her constitutional rights and her human rights and her inalienable rights did not like that. April again inserted her innocence and wished for a trial, and Thomas Donegan ignored her. They spent several hours trying to get April to plead guilty and changed the name of the guilty plea to Alfred. Alfred, please go Google it, look it up. It's nothing but a guilty plea in so-called still inserting that you're innocent, but has all the elements of a guilty plea. And why do they want April to plead guilty? Thomas Donegan also continued to use a false document that the state of Wisconsin, the prosecution knows to be false document in relation to this so-called criminal offense. The criminal offense, again, is a charge, a fraudulent charge doctored up by way of parties assisting this Ugandan rapist. The charge April is currently charged with is interfering with custody of a child. I'm going to show you all this criminal complaint. I don't know if you can see it, but I'll read it to you. It says the above complaining witness duly being sworn. The above complaining witness was Christopher Moles, the police officer who broke April's baby bones, one of the many officers, and paralyzed April, who came in April's residence, her home where she was at, with her son, exercising her custodial, constitutional, human, and natural rights with her children. And he states that between June 25th, 2007 and September 26th, 2008 in the county of Milwaukee, Wisconsin, the defendant April Griffin did intentionally conceal a child to witness to wit Jesse Moses Griffin Sabaliva, which is we don't even know who that child is, or agree to anyone to change her son's name without her consent, knowledge, and it just has not happened from the child's father, Matthew Sabaliba, contrary to Wisconsin statutes 94831, subsection 3, subsection A. Now, in a criminal complaint, is the burden of the state to prove all elements of the offense. They said he's the father. What is the definition of a parent? Can they prove that at trial? No. He's not a parent because how he conceived the child with April was through a criminal offense, a criminal act, sexual assault. So, uh, Thomas Donegan continues to use a paper that's attached to the criminal complaint, which was a June 25th order saying that April does not have custody of her child. Who doctored that order? It was D'Angela Ellis, the lawyer and other close relationship status with the Ugandan rapist who doctored that order and doctored that paper. Now, where did this order come from? We have no idea. There is no court hearings with this order. April was never given notice of this order, and this violates due process. How can you do an order altering a judgment? A judge doesn't have the authority to alter a judgment once a judgment is in place. What order is that about? I mean, he can't do anything of that nature. So, I wanted to also show you all some other documents that contradicts the so-called order. If you all will see, this says a motion hearing, November 13th, 2007. I don't know if you all can see that. Can you see that motion hearing? Held before Michael Gooley. Okay, this was. Let me see if you can see the date on here. November 13th. right here. See, you see that? 2007. That's subsequent to June 25th, right? So I'm going to go into what this hearing says. The court, in reference to Michael Gooley, who didn't have jurisdiction, or April did not have jurisdiction, doesn't have jurisdiction, and usurped his jurisdiction. The law enforcement authorities could say, well, April Griffin does not have custody now. If she's holding a child, we can do something about it. We have to give the father the ability to use the law enforcement and other people to seek this child, get this child, and not allow the mother to stop that by saying, I have custody. That's the reason I gave sole legal custody, and it is temporary thing at this point. It will be determined later at a hearing, but we need that to enforce the court's order so the law enforcement authorities will do their thing. The court has ordered sole legal custody to the father to effectuate the law enforcement activities to get this child here. Now, you all will say, well, he said he ordered custody. Uh, but did this judge have authority to do that? And you see, he said he ordered just so the police can get her child. Why would the police say that? Now, I'm going to read some more transcripts from that very same hearing. This is D'Angela Ellis talking. She said, Your Honor, your order that was entered on June 19th of this year, giving my client primary placement in sole legal custody. I am asking that the court order Ms. Griffin to hand the child over to my client immediately. June 19th. You hear nothing about June 25th. Why does she say June 19th? Bam! Here's a June 19th order. The June 19th order is blank. The June 19th order doesn't say anything about handing a child over. All it says is that Matthew Subaliba is ordered to pay child support in the amount of $10 a month. Per continuing order. Continuing order of what? Of the January 29th order of Frenzy, some Frenzy man, a commissioner who's not even a judge, who ignored April and her pleas about the assault and what have you, and ordered joint custody. Then you have a procedure before June 25th that was done by Michael Gooley, stating that if April Griffin is willing to surrender her child, the Bureau of Milwaukee Child Welfare should be notified to facilitate the pickup of Jesse Griffin and place him with his father as soon as possible. April release is contingent upon her compliance. Now, this was June 6, 2007. Why are these orders to take her child? June 6th, also May 14th, May 16th, but the criminal complaint says June 25th because June 25th was an orchestrated, doctored order by D'Angela Ellis, who went to Judge Michael Gooley's chambers without notification to April, what have you, and orchestrated this document. Gooley signed it and got the police involved. You got a document stating that the Subaliba, the Ugandan rapist, is asking the court to uh, let him remove the child from the country. There is a hearing scheduled for April 26, 2010 at 1:30. How can they order things they don't even have jurisdiction? And a rapist, you see also a transcript that says April 24th transcript before it even went to Judge Gooley. April again says the way the child was conceived was not consensual. The court ignores her. She even turns to the rapist and says, Matthew, the child was conceived. It wasn't consensual. You know this. And they ignored her. Continuously ignored April in court.